In preparation for the Kate O'Regan competition taking place on the 5th of September this year, right at UCT in Cape Town, we have here today Mr Andile Zulu from Phatsoane Henney coming in to give us better knowledge of how you can prepare for this moot court competition. We have Mr Andile here because he's done quite a bit of work already in the AI space. I mean, if you're talking about AI law, what's happening in that space, I think having Mr Andile Zulu is probably the best move to make, especially if you're here in the Free State. And because of that, we have him here to give you a little bit of a crash course, kick-starting with the introduction of why is he the relevant person to talk to us about automated decision-making and human rights. Yes, that's the theme for this year's Kate O'Regan Moot Court competition. I'm now going to hand over to Mr Andile Zulu, who I hope is more than ready to lead us forward. Mr Andile Zulu, are you ready?
Yes, ma'am.
How are you feeling about this session?
I'm very optimistic, and I think a lot of people would actually learn a lot, especially the students would learn a lot from this session. And not even this problem only will equip them with the right knowledge, but also going forward, because this is where we're headed to as a country and as the world.
Side theories. Mr Zulu, please take us through.
Thank you so much for the opportunity. I really appreciate it. And I'm sure a lot of people would actually want to know that, okay, why, as you said, am I a relevant person in this? Well, I'm currently doing my master's dissertation in AI accountability or liability, if I may put it, which looks at if AI makes a mistake, who actually takes accountability for it. I'm actually going to give a quick yet striking scenario. Let's say you chat with a robot, which represents a certain airline, and that robot tells you that, listen, if you book an airline today, it's actually much cheaper to actually book the airline today than tomorrow. On that decision, you actually buy the ticket. Tomorrow, the ticket is actually way less than what you bought it for yesterday. Now, who takes the accountability for that loss that you have had? Now, the airline will say, no, it was not us. It was the AI bot which actually made you to buy the ticket. It's not us. When you turn to AI doesn't have a legal personality. Now, who do you blame for that lost money? So it's things like these which are very interesting, you know. And my academic and professional background lies within the intersection of law and technology, particularly in the field of AI and also data governance. And I feel like this competition, the problem is especially relevant with me in engaging much more with it, because of the growing use of algorithm decision making by states, which raises important questions such as accountability, fairness, protection of fundamental human rights within administrative law. Now, if you'd allow me, Ms. Pinky, to turn to the facts of our problem. Turning into the facts, the matter concerns the introduction of an automated school placement system known as EduMatch by the Western Cape Education Department. The system uses a range of data inputs, including the learner's residential addresses, socio-economic indicators, school performance metrics, and capacity constraints to allocate grade 8 learners to public high schools. While the stated purpose of the system is to improve efficiency, reduce corruption, and promote equitable access to quality education, the key feature of concern is that the placement decisions are made automatically without no human intervention, which it raises a significant problem. The dispute arises from the circumstances of a learner who is named AB, who is a high-performing student, but was placed in a low-performing school instead of her preferred high-performing institution. The decision placement or the decision making or the placement decision was communicated through a standardized automated message without reasons that were given on why actually that school was actually picked instead of another school which was desired by the learner. Although an internal appeal was lodged, the explanation provided remained broad and failed to disclose the underlying logic of the algorithm of the system. Importantly, the department refused to disclose critical information such as the weighting formula, predictive modeling criteria, and algorithmic structure of the system. Now, remember, if a system is going to make a decision, it must be based on reasons. And the main fact is that in this automated decision making, there is no human intervention. Remember, this is an administrative action. To deny or to accept a student into an institution of higher learning will form part of an administrative decision. Now, since the department refused to disclose reasons and what basis did the AI machine actually, or the AI software made its decision, they then decided to take the matter to the High Court, where the applicant, which were the parents, urged that the decision violated several constitutional rights. Firstly, the right to equality, the right to dignity, basic education, and just administrative action. Remember, this problem circles around administrative action and also automation and automated decision making. It's in you having to find a pattern around that and able to interpret the law and apply it on the current situation. The applicant further contended that the lack of transparency and absence of meaningful reasons rendered the decision procedurally unfair under the PAJA Act, being the Promotion of Administrative Justice Act. Now, the High Court ultimately found that the placement decision constituted an administrative action, as I've stated, and it was unlawful due to the failure to provide adequate reasons. However, the court declined to declare the EduMatch system itself unconstitutional, and it instead remitted the matter for reconsideration. And that's why you have this case in front of the Supreme Court of Appeal. Rule of law which will be applicable here is, firstly, your primary rule of law, which is the Constitution, and it mentions these sections explicitly. For instance, the right to just administrative action, which is under Section 33 of the Constitution. Right to basic education, which is under Section 29, subsection 1, subsection A. Right to equality, which is under Section 9 of the Constitution. Right to human dignity, which is under Section 10. Now, I mention these sections because you would have to rely on our primary legislation, which is, of course, the Constitution itself. Now, in anything or in everything that you do consider these sections as they are your primary rule of law.
So, Mr. Andile Zulu, now that you've covered the facts and you've broken down exactly what to focus on and what's the relevance of these facts and just some of the legislation that's applicable, can you just tell us a little bit on why is the rule of law, or knowing which parts of the law is applicable, why is it relevant to your facts? Why is that something that you should take to heart or invest quite a number of your energy into? And I think I'm also asking because you are a researcher, right, at the Supreme Court of Appeal.
Yes.
So I think that also you'd be able to give us a better understanding on why is your research so important.
So important, yes. Thank you for that question. Definitely, at the Supreme Court of Appeal, we worked in various cases which were provided a basic issue, and you would have to actually go out there to answer those issues. Now, the reason why you should actually focus on this is because you're taking law and you're applying it on the set of facts that are given. Even if a case doesn't come up with exactly the same facts that you're dealing with right now, but what we look for is the principle that judgment or any case would provide for us in order to support our case or our court. Now, the first legislation, or the first piece of legislation I want to introduce you guys is PAJA, Promotion of Administrative Justice Act. Now, what is the reason for this act? Every decision that's done by an organ of state or a governmental state, or any decision that is detrimental to your success or anything of a sort, this act is very valuable in that, because you must be able to provide, or the government or the organ of state must be able to provide reasons why it has actually denied or accepted you to do a certain matter for some sort. For example, you have been denied to be given a passport by Home Affairs. Remember, Home Affairs is an organ of state. It exercises power through Home Affairs in making sure that all issues which involve citizens are solved. But you've been denied a passport. Mind you, you have actually achieved all the requirements that there have to be in order for you to get a passport, but you've been denied. government or the act requires that Home Affairs provide you with substantial reasons as to why it has been denied. Now, this is the very same reason that this act is very important in this scenario, because the child AB was denied to actually go to the school of choice she wanted, instead was given another school. Now, there must be adequate reasons which must be provided for this. Now, in the Paja Act, what you look for are these sections. Number 1, procedural fairness. Did the automated decision machine EduMatch, while making its decision, conduct a proper procedure, or was it fair in its procedure? You look at procedural fairness in section 3. Number 2, section 5, which provides the duty to provide reasons. But I want you to note 3 things. The reasons must be adequate, they must be clear, and they must be meaningful. And to answer the question of this problem, standardized automated response is likely insufficient. It doesn't provide an adequate reason why it was actually denied. It doesn't provide a clear reason. Now, number 6, section 6, which provides for the grounds of review. This decision must be reviewed because it is served unreasonable. It was irrational because it's made by an automated decision-making machine and not human intervention. The most important section which I would also want you to look at is section 8 of the Paja, which speaks on the remedies. Now, what are the remedies that you can actually sort under the Paja Act? The first remedy is remittal, which is used by the court. Number 2, substitution, meaning that substitution, we are going to substitute that decision which was taken for a much fair decision. Number 3, a systematic reform, which I would kindly advise you to look at in this section, because we want to remove the automation and make it to be human involved. Well, it's up to you. Do we remove it? Do we not remove it? That's up to you to answer that.
Thank you so much for that perfect analysis of our primary laws. With that overview, can you tell us a little bit more on how can you as a student then better prepare the rule of law or the legislation that you use for this case?
What you can look at is, I have focused on all the internal laws which you can actually look at. For example, I've spoken about the Constitution, I've spoken about legislature which you can actually look at, but now you cannot convince me in your case if you don't even have a single international instrument. I'll take you through this section. Section 39, subsection 2 of the Constitution says, when interpreting the Bill of Rights, a court, tribunal, or a forum, any legislation must consider international law and may consider foreign law. Now, I say this intentionally because in your argument, I need to see, or a person needs to see, that you have actually considered international law.
Okay, so Mr. Zulu, just to raise a question right there for my students particularly. Now, how do you as a student, how do you give yourself that confidence to look into international law? Maybe give us some references from your time doing research. Like, did you ever look at international law, and where do you even start?
It is very important for us to look at it because it gives your argument a very strong basis. For example, we as a country, we have actually agreed to be part of these treaties. You know, there are international treaties such as the United Nations Convention on the Rights of a Child, which speaks directly to the best interest of the child and the right to education. What does our Constitution say? It supports the right to education of a child. Now, back then when I was doing research, it was very important because you'd find some scenarios that are not applicable in South Africa. It's the very first kind that we have this legal problem. But you would find a country such as the United Kingdom, which is way ahead of us in terms of their law and jurisprudence. That's when we now have to look into their law, of which our Constitution does say that we may look into foreign law. What have they done in their own jurisprudence? What can we then apply in our own national law? The treaties that we have ratified, meaning we form part of them. The International Convention of Economic, Social and Cultural Rights, United Nations Convention of the Rights of the Children, the African Charter on Human and People's Rights. All of these charters we've ratified, and we must consider them in our law also, especially in this scenario where it's the first of its kind. It's a machine which is being used. It's a machine which is actually making automated decisions.
And I'm assuming that there's not going to be a lot of case law, right?
Exactly.
Okay.
There's not a lot of case law which we can look at internally in our country. If you go to into the United Kingdom, America, you'd find 3 or 4 cases of which we would then look at the principles that were adopted by the courts. And I would really advise students to actually look at the United Kingdom approach, because why? We have the same thing which is called common law. Our common law and their common law is similar. The United States law, very different with our law, meaning that when we look for jurisprudence and decisions, we most focus on the United Kingdom or England for the most part.
Look at like what's familiar to what we're already doing.
Yes.
Mr. Andile Zulu, this has been quite an amazing introductory session. I wish I could actually compete. I'm going to give you a chance to just wrap up by telling my students what are your expectations from them as they prepare for this Kate O'Regan Moot Court.
First things first, don't be scared. Engage with the problem. In terms of expectation, I require that you engage meaningfully with the administrative law jurisprudence, particularly case law dealing with procedural fairness, the duty to provide reasons, and the standard of review. Cases such as Batu Star Fishing versus the Minister of Environmental Affairs will be central to your analysis, especially in relation to reasonableness and judicial deference. You should also consider other leading authorities that address rationality and legality, and other case law which provide reasons as to the decisions or administrative decisions that are actually taken. And remember what we seek at the end of the case. We want a declaratory order. I want you to actually find case law which provides us with reasons or provides us with a rationale on when do courts actually grant a declaratory order. Now this, you're going to use it in your end when you ask for your prayers. You seek for a declaratory order, and the reason you're seeking it is that in the case of, it was actually granted. Now that's a guideline. Importantly, I expect your arguments to go beyond superficial assertion. Don't just say it's unfair. Provide me with substantial reasons why it is unfair. Use your case law. Quote your case law perfectly. Quote the principle. Definitely, you're going to provide the court with good reasons. Thank you.
Wow, it was so good. I almost said, in Jesus' name, amen.